Welcome to Savvy Estate Planning. Avoid the top 10 mistakes. I am Jim Cunningham, and I'm a lawyer. This is information only. Don't watch this and go out and do a bunch of stuff, but this is really for your education. I'm the managing partner at Cunningham Legal, 25 years experience. We have offices throughout the state of California. We do help clients in Missouri, Texas, Virginia, the state of Washington, and the District of Columbia. We do have attorneys licensed in those jurisdictions. I'm a certified specialist in estate planning, trust, and probate law, a real estate broker, securities insurance licensed, and a pilot. If you're watching this on YouTube, subscribe to our YouTube channel, and you can click the share button. So if you think there's somebody out there who could benefit from this information, please share it. These are our lawyers. We are devoted entirely to trust and estate matters, tax planning matters, all that sort of fun stuff. And so our locations are in Northern and Southern California. You can see the Golden Gate Bridge, and maybe that's San Diego. I don't know. Maybe it's Santa Monica, somewhere in Southern California. So big news, second edition of my book, Savvy Estate Planning, what you need to know before you talk to the right lawyer. And we're going to be going through essentially a commentary of the book, and I will be talking about the top 10 estate planning mistakes. So this is not a substitute for the book because we go into much greater depth, but this is sort of my view and commentary on each chapter. So you can order this, go to our website. And so if you go to our Cunningham Legal website, you can go ahead and click estate planning book, and you'll find that on the website. It'll take you to a link in Amazon, and it is available on Kindle as well as hardcover and paperback. So this book, The Top 10 Estate Planning Mistakes, focuses on the 10 things to avoid. And these are kind of like a punch list. You know, it's framed in the negative to really make it clear, as opposed to saying this is what, you should do, but it's avoiding what you shouldn't do, because knowing what not to do, right? Knowing what not to do sometimes is more important than knowing what to do. So I would say many families avoid a couple of these, but I do see estate plans. And I was just meeting with a client this morning that had a plan of distribution that just, it addressed 2 of 3 possible outcomes, but didn't address that third outcome. And it was a real serious problem, potentially, if certain things happened in the future. So very important to pay attention to these top 10 estate planning mistakes. Education, I will tell you, we live in this era of webinars and Zoom. And that's one thing COVID's done, is it's accelerated a lot of the change that would have otherwise happened, but it would have happened, 10, 15 years, and it kind of compressed it into about a week. So the other thing is education is also key to creating an enduring legacy, because when you leave this earth, and we all do. My mother-in-law passed away about a couple of years ago, and maybe in a week or so, it'll be a couple of years. And it was a very strange thing. My wife's mother, who I've known, my wife and I have been married 30 years this year. I've known her for 30 years, and then she passes away. And it's just weird because, all the stuff stays behind. The people are still there. For those of you who've lost a loved one, you know what I'm talking about. But creating this legacy, and what we're talking about here is we're talking about money, but money means different things to different people. So money is essentially an abstraction, okay? And this is what we're going to go through here. May require a shift in mindset. And so what I mean by a shift in mindset is different people think about money differently, and it means different things to different people. When I talk legacy, some people immediately jump to money. That's not always the case. So you have your family values and a lot of other things that can be passed that aren't just money, and it's part of your legacy. It's part of your overall estate plan. So what you know is in the green. What you don't know is in the blue. But there's this whole big red-orange area of you don't know what you don't know. That's what gets you into trouble. It's easier to see if something's wrong than if something is missing. Okay. So what I mean by that is it's easy to point out the hole in the donut, but it's hard to know that something should be there and it's missing. That is really where it takes an expert. And so unfortunately, with many estate plans, we see a lot of stuff missing. So let's get right to it. Number 10, letting your family go to probate. I'm not going to spend a whole lot of time on this. Probate is always a hassle. Okay. I will tell you. And I, privately, lawyers talk about about probate and also conservatorships, and I'll talk a little bit about a conservatorship. But basically, there's a problem. If an estate goes into probate, there's some kind of problem brewing, okay? And it used to be that probate, when I started practicing law 27 years ago, there was a lot of probate. There's not as much probate, and they kind of are getting weirder as time goes on, right? There's some underlying issue typically, whether it's the family or the person. And so it makes these probates, they tend to be thornier, okay, than they used to be. Sometimes probate is a nightmare. And I don't say always it's a nightmare, but one of the things that's happened lately with COVID is the courts are a lot slower. So we recently filed a petition in probate court related to a trust. So this is very important to understand. Letting a family go to probate a will is different than a trustee taking a matter to court for a variety of reasons that are kind of outside of the scope of what we're talking about here. But we recently filed a petition in a trust matter in the probate court. Our hearing is 9 months from when we filed that, 9 months from when we filed that petition, okay? The minimum time required is 30 days by statute because you have to file and then notice people that there's a petition. But these probates have become much, much longer because of what's going on with COVID. So I would say it's gotten worse. Probate's expensive. So $1 million estate, let's say you own $1 million home and a $900,000 mortgage, your probate fees are $50,000. All right. So that's half the estate because the probate fees are based on the net, based on the gross value of the assets, not the net. Death taxes, of course, are based on the net, but the probate fees are based on the gross estate. All the full market value, regardless of debt. So you have to pay probate fees on money that ultimately goes back to pay creditors. So a lot of people, they kind of are surprised, right, when that happens. Again, COVID, it's just everything's taking a lot longer. Intestacy. So this is a real common question. What if you die without a will? That's called intestate. So without a testamentary document, okay? If you have a will, you still go to probate. Okay, so that's very important to understand. It's a living trust that keeps you out of probate. Probate is public. So the P's, probate, public, and living trusts are private. Generally speaking, they're not public. They are trusts. There's a requirement to give a copy of a trust after somebody passes away to those who inherit or would have inherited in the absence of a trust. So mistake number 9, assuming all trusts are the same. So what is a living trust? If you have one, many people, they have these things and they go, I know I had to do it and I really don't understand why. So what the heck is going on? Well, a living trust is like a super will. Okay. So a will is only effective at death. So for that document to be effective, to be legally enforceable, it happens after you pass away. A living trust is a little bit different. And this is why it's called living, because it's effective while you're alive. And this is very, very important because part of the probate system involves what we call conservatorships. And a conservatorship is a guardianship for an adult. In California, we call it a conservatorship. Other states call it a guardianship. A living trust keeps you out of probate court in the event of incapacity. Okay, it's designed to keep you fully out of probate court if it's set up properly. And so you can think of a living trust as a bucket. So it's this bucket, and you put your house, your stocks, your bonds, your mutual funds inside of the bucket. And then you hold on to that bucket. And when you stop being trustee, because you get hit by the beer truck and don't die, right? If you can't be trustee because you're in the hospital, that bucket's passed to your successor trustee, who is very important that they know what to do and they're trustworthy because there's no court supervision. And then certainly, if you get hit by the beer truck and die, of course, you're not trustee, and then they go ahead and distribute those assets according to the terms of the trust. There are trusts that are designed to protect against your heirs, lawsuits, creditors, predators, and divorce. So what I'm talking about here is there is a structure that we'll talk about in a couple of slides where you can protect. It's designed to protect the inheritance that you are leaving somebody, not your own issues, right? But the inheritance that you leave your loved ones. There is a mechanism that is designed to protect that from a divorcing spouse. So what we're talking about here is, a person passes away, and the son inherits the assets, and the son's married, and then the son's spouse decides to get divorced. And then, the question is that separate property? Is that community property? Is that subject to a 50-50 division? If it's community property, or if it's separate property, is it not subject to that 50-50 division? And unfortunately, without this extra wrapper and protection, a family law court's going to decide that. And if you don't have it, a structure to protect it, it's a lot easier for the judge in that case to rule that this separate property inheritance is actually community property because of things that happened after the inheritance was received. So very, very important. If you care, there's something you can do about it. All right. So, and that's, we're going to talk about that. I would say, living trusts, most living trusts that we see do not protect an inheritance from divorce. Most living trusts we see are not personalized. These are ones that our firm does not do, right? We do very personalized estate planning for our clients. So it's not enough to get a paralegal, right? You can't, this is not a do-it-yourself project. Trust law, I will tell you, every year gets more complex. It does not get less complex. It gets more complex. More laws are passed. I mean, think about it. I mean, I think the state of California passed, I don't know, it's either 700 or 7,000 laws last year. I think it was 700. They're not taking any laws off the books, right? Typically, they're just adding to. And so we had, if you go on our YouTube page, we had a big change in the law that affects all living trusts. When a person who sets up the living trust is incapacitated and stops being trustee, there are a new set of rules for that. So if mom sets up a living trust naming son the trustee, and mom has a stroke, and now son is the trustee, the son has extra duties this year, effective January 1, that the son did not have last year. And then the process for a customized plan. What is the process? What does the process look like? We are very process oriented in our law firm. We have lists of everything. If this happens, then there's this task list of things that need to be done. We're not winging it. We're very process driven. And this is really important because this is very important. It is very complex. It is routine in our firm, but it is complex. And so given the complexity, and this comes maybe a little bit from pilot training. Pilot training, you have checklists that you go through before you give it throttle and take off. You have to go through a series of tasks on a checklist, and that makes flying safer than if you don't have the checklist. So it starts with education. So right now, this is it, education, right? We have over 100 YouTube videos on our YouTube page. I really would encourage you to take a look at that. A diagnostic. So a diagnostic is a lot like going to the doctor's. Before you go to the doctor's office, they might say, get a blood test, fill out this questionnaire. That's before the doctor meets you. We go through a similar thing when you meet with one of our attorneys. We need this information. We need your financial information. We need your family information. We need to know what issues there are. We need to know, if you want to disinherit a child, we need that child's name, because that child needs to go in there into the estate plan saying that they don't receive anything. Otherwise, they might, if you don't name them and give them nothing. If you omit them, there's a whole body of law out there that says, oh, well, they were a forgotten child. So it's very important that we get all the details. And then there's a meeting with a lawyer. And we're doing a lot of these by Zoom. We're still doing in-person meetings, but I would say the vast majority are by video conference. And then all of that data is reviewed by a senior paralegal who has his or her own punch list of tasks to go through. And that's very important to have a second set of eyes. And the paralegal's job is to make sure that we have all the information, make sure that it's in a manner that we can use it, and it's helpful to the estate planning process. And then we use software. So if all lawyers, I don't know any lawyer who's sitting at a typewriter doing this to do their estate plan, right? We all use software, whether it's Word or whether it's a document assembly software. There has been a movement in the estate planning field to use document assembly software. It does not mean it's a bad thing. You actually get a superior estate plan for a much less of a fee. Okay, so there's some operational efficiency in there. And then we create the draft of the documents from that software. We review those documents to make sure that they're correct and accurate. And then we give the draft of the document to the client to review. Now, Some lawyers don't do this. Some lawyers say, some clients say, why are you giving me this trust? You expect me to read this thing? This thing's like, 6 inches thick or whatever it is. It's important for you to have the opportunity to look at it. Many of our clients read every word. Many don't. So it is up to you, but we have a policy in our firm of providing those drafts before they're signed by the client. And then once they're signed and notarized, then those documents are returned to the client, and we keep everything electronic. We do not keep a paper file, but the client holds on to onto the physical documents. And then there's continuing education, client education, and regular reviews that we do for our clients. So to check out our YouTube page, go ahead and subscribe to it. It'll pop up in your feed if you subscribe. So this is the education. A lot of our education now lives on YouTube. And what we do is we do these weekly webinars and we post them on our YouTube channel, and we get really positive feedback. So I think people are really enjoy. Well, I don't know if enjoy is the right word, but I think people get a lot of value by watching these videos. So forgetting to plan for disability. Okay, I think this is probably the single most overlooked aspect of estate planning. If I had to pick one, people tend to know to avoid probate, and people know they want to minimize taxes. But one thing that's hard to think about is his living in the future. You have a very high probability of being incapacitated before you pass away. Most people are. Now, when I say disability, that's a little bit different than incapacity, but just go with me on this one. I think a disability or an incapacity is harder on a family than a death. And I know this from my own personal experience with my in-laws is, when somebody passes away, you're just dealing with the stuff, right? Who gets this? Who gets that? If they're alive, you have to deal with the person. And, if it's your mom or your dad or your spouse going to the hospital in this era of COVID, which my father-in-law has been into the hospital several times during COVID. He's 90. He's going to be 90 in a couple of months. It's a real pain in the neck, right? I mean, it's a pain just functionally getting to the hospital and dealing with all the stuff you have to deal with. Even before COVID, it was a tall order. But I would say it's harder. That incapacity can be harder on the family. Who's the caregiver, right? Sometimes a caregiver dies before the person that's receiving the care. It's nuts, right? Because it literally wears people out. Well, what if you have no plan? Or what if you have a will and that's it? That's a conservatorship. So if a person is unable to do for themselves and others have to do for him or her, you need to go to get a conservatorship, which is a very involved process. So what it is it's a court ordering that this person who is now incapacitated no longer has the right to decide where they live, no longer has the right to handle their own money. It was like Britney Spears, right? And then she just came out of that conservatorship. I would say at a minimum for budgeting purposes, I would budget $25,000 in the first couple of years for a conservatorship. That may be on the a slightly high side, but I will tell you, and this is not just attorney's fees. It's a good chunk of that's attorney's fees, but the incapacitated person also has to have a court-appointed lawyer. There are public agencies that conduct investigations and send the bill to the person who's ill, right? They send the bill to the incapacitated person, and that incapacitated person's responsible for those court investigator reports. So conservatorships can be avoided with proper planning. We mentioned the living trust. We mentioned a pour over will. A pour over will is a will that leaves everything to the trust. So it pours over, right? Whatever, if you have $100 in a bank account that's not in your trust, that $100 account will get over into your living trust. A durable power of attorney for property. Durable powers of attorney, I think, can be used for good and evil. We see a lot of people taking advantage of elders with a durable power of attorney. It's kind of a scary document. Sometimes they're a 2-page document. Sometimes they're a 25-page document. But the state of California has published a uniform statutory form power of attorney that really anyone can download online and put it under an elder's nose, and that elder signs it. It's notarized, acknowledged before a notary public. It's a technical term. and then they can stand in that elder's shoes, right, or that person's shoes and do a whole bunch of stuff. So you really need to choose carefully your agent under the durable power of attorney, and that handles all things financial that exist outside of the living trust. Now you may say, Jim, well, if I put my house, my stock, my bonds, and my mutual funds in my living trust, what else is there? Well, there are IRAs and 401ks, life insurance, annuities. Those are typically dealt with the durable power of attorney. Something to understand, a trustee of a living trust must follow the terms of the trust. That person is a fiduciary. A durable power of attorney has a slight variation on that. Not only is the agent under the durable power of attorney a fiduciary, but the agent has what's called agency authority. And that means that the agent can bind the principal. A trustee of a trust can only do what the trust allows the trustee to do. But if you appoint an agent can do anything that you can do. So you can see the difference. In a sense, the durable power of attorney has a much broader grant of authority than the trustee of a trust. So I know maybe it's a little down in the weeds, but it's very important to understand the difference between the two. A durable power of attorney for property dies with the person who has granted the authority. So if you sign a power of attorney, when you die, that power of attorney dies with you. Important to understand that. Advanced healthcare directive or power of attorney for healthcare, those are documents that we recommend our clients have that lists who makes healthcare decisions for you if you are unable to make them. And here's another mistake I see in estate planning documents. It says this durable power of attorney for healthcare, this advanced healthcare directive, they mean the same thing in California, is effective when I am no longer able to make my own decisions. And I give these people access to my health information. So there's a gap here, which is, what if I'm not incapacitated? What if I'm in the hospital and I need my wife to go pick up some medical chart or something, I don't know, some x-ray or whatever it is. She's not going to be able to get that without a HIPAA authorization. So you know what HIPAA is, medical privacy. She's not able to access that without a HIPAA authorization. So we break those up into two documents in our firm, and that HIPAA authorization is valid the moment you sign it. So if you want someone to go pick something up for you because you don't want to drive across town, they can go with that HIPAA authorization and do that. So it's a very important document. A living will says pull the plug if I'm a goner, essentially. Some people want that, some people don't. That sort of pulls at people's religious beliefs, and there's a whole lot going on there. I just list it here as something to consider. I'm not going to tell you to do it or not do it, but that's something to consider. And this is really important. You nominate a conservator or an executor. Now, a conservator is the person who does stuff, right, for a conserved person, a conservatee. So a conservator does stuff for a person who's under conservatorship. An executor does stuff in a will, in a probate, right? So executor is appointed by the judge. A trustee or a successor trustee does stuff in a trust. So these are many times are the same people. They're very similar roles, but in law, we give them a different name. So we know if somebody says conservator, I know, oh, okay, we're talking about a conservatorship. If someone says executor, we're talking about a will. It's very important to understand that you nominate a conservator and you nominate an executor, and a judge decides whether that person can actually serve or not. So you have to go through a petition process, a background check. You have to jump through a bunch of hoops. You have the power to appoint a trustee without seeking court approval. And that's another big, division between conservatorships and probate and trusts. So you can see why it's a little more efficient to appoint somebody rather than go through a court petition. Pre-need planning is basically prepaying your funeral services. If you have parents, if you're the most responsible kid, and you're going to end up paying for the funeral out of your own pocket, right? You may want to prompt your parents to do some pre-need planning. Do you see where I'm going with that? Because, somebody passes away, it could be a $30,000 bill. You have to pay that. And you typically have to pay that before you have access to mom and dad's money, because you need a death certificate. You need all these things before you can actually, be a successor trustee under a living trust. So there's a sort of a payment or a timing issue there. Pre-need planning is where you go to a funeral home, you say, this is the flowers, the cake I want, the casket, whatever it is. And they say, okay, that'll be $20,000. You write a check. That money goes to an insurance company. It does not go to the funeral home, because if you write them a check and they go out of business, I mean, that's not working. So what you do is you give that money to an insurance company. So when you pass away, that insurance benefit, that life insurance benefit pays for the pre-need planning. Role of a living trust in pre-need planning, very, very important. You can have the trust own it. You can, so a lot of times those are integrated. We mentioned what if the caregiver dies first, and long-term care insurance. We've got a couple videos on long-term care insurance. There's the old way, which is paying monthly. There's the new way, which is you write a single check. You might write a check for $50,000 and get $150,000 in long-term benefit. And if you never use it, your kids get the $50,000. Right? You see what we're talking there. So you give some money to an insurance company that kind of hold your money hostage for your lifetime. And if you need it, it's there for long-term care. And if you don't need it, the money goes to your kids. So we have a couple of questions here. We'll see if we can answer those. Anonymous asks, will the successor trustee is the trustee to make decisions when the living trust becomes irrevocable after passing of the husband and wife? Yes. So the successor trustee, I think I know what you're asking, Anonymous. The successor trustee becomes the trustee after the parents, the husband and wife, die, and they make decisions after death, but the trustee has to follow the terms of the trust. So they're bound by the terms of the trust. Kelly asks, is it overkill to have both an advanced healthcare directive and a living will? Kelly, sometimes the living will statements are inside of an advanced healthcare directive. But I find that one of the problems is when you're, certainly with Kaiser, when you're admitted to the hospital, they make you sign a new durable power of attorney every time. So if you don't have a separate living will, I'm concerned that you may not be checking the box. You may not be paying attention to it when you sign a subsequent advanced healthcare directive. So I think, if we were living in a static world, is it overkill? Potentially, but I'm a little concerned that you might sign a future advanced healthcare directive and not address the end of life decision-making, and just frankly not address it. And the purpose of a living will is to give permission to the decision makers, give them permission to essentially pull the plug, for lack of a better term. So failing to protect beneficiaries from themselves. Okay, so what are we talking about here? Sometimes people inherit a big pile of money and blow it, right? Sometimes they blow it. Sometimes they lose their public assistance benefits. So this would be a loved one who inherits from you who is on SSI, supplemental security income. That's a needs-based or needs-tested public benefit. And if they inherit a bunch of money, guess what? They can get kicked off of their, they're not going to get their SSI check. They may lose their HUD housing. They may lose their client status at the regional center. There's a whole bunch of stuff that goes with, if you have a loved one with special needs, you really need to start thinking about a special needs trust. And if you have a special needs trust, please take a look at it and make sure it says what you want it to say. Now, what do I mean by trust your trust, not the person? So some people say, I want to give, I don't want to disinherit my daughter. And this is a story we have in the book. I don't want to disinherit my daughter, but I know if she gets $1 million, her husband's going to end up with it. They're just going to blow through it. And, she's 60 and I'm 85 and I want her to have enough money in retirement. Okay. So something else, when I said the mindset shift, inheritances more and more and more are inherited by people who are in retirement years. So the people who inherit are old. Okay. Don't take that the wrong way. What I'm saying though is 50 years ago, these might've been younger people that inherit. Well, now there are people who are looking at retirement. And my grandfather had a pension from General Motors. That was fantastic. He was a factory worker, great pension. Those days are gone. A lot of people now, they have 401ks, they have IRAs. Many people are relying on an inheritance to essentially fund retirement. So what do I mean by trust your trust, not the person? In this case, where the daughter is not financially responsible, she's not a bad person. She's just financially not responsible. That money goes into what we call a continuing trust, and we give that a name. It's a dole it out trust. It's the money is doled out, right? Maybe she gets $5,000 a month for the rest of her life or whatever the number is. But my point is, give her a stipend, for lack of a better term, a monthly amount rather than a lump sum that she's going to blow. Now, it's very important if you have a continuing trust, like a dole it out trust or a special needs trust, it's very important to consider a trust protector. We do have a video on our YouTube page about a trust protector. And this is a fairly recent thing, maybe the last, 25, 30 years, 15 years. A trust protector is a person who has power over the trust, but is not the trustee. I did say that a trustee must follow the terms of the trust, but what if following the terms of the trust doesn't even make sense? And the example I use is if you're in Northern California and you're going to drive to Southern California, and the trust says you must take Highway 99, or the 99 if you're in Southern California, that's what you might call it. And you go, well, that doesn't make sense. We got to go through Fresno and there's a bunch of trucks and we got to go through all these cities and it's just not going to be as fast. It's not going to be as efficient. Wouldn't it be nice if we could go down Highway 5? Well, if that trust was written before Highway 5 existed, right? You actually have to go to court to go down Highway 5. You've got to go to court to change that. And a trust protector can change that. Okay. They can change things that make sense, that people agree on without having to go to probate court. So very important, really important on these continuing trusts because they can last for decades. Okay. And planning for change, you have, the trust protector lets you address future changes, again, without having to go to court. It's hard to foresee it is hard to foresee the future, but these estate plans should be written, the trust should be written in a way to be nimble and adapt to changes. So letting third parties take advantage of your beneficiaries. So many of our clients, most of our clients, if they're leaving anything of value to their loved ones, they use what we call an inheritance protection trust. This inheritance protection trust is designed to protect the people you are leaving money to. It's designed to protect the money from divorce creditors and predators. Now, divorce, it helps in maintaining the separate property status. So it's not subject to a 50-50 division of community property. This is after the loved one inherits. Creditors, I mean, it's pretty obvious. And predators. So who are predators? Well, maybe someone who might take advantage of somebody, but more and more we view the government as a predator in the sense that you have to pay taxes. And sometimes these trusts can result in a lower overall tax bill if you do it correctly. So I know I'm being kind of vague, but the point is for many of our clients, they choose this inheritance protection trust because it reduces taxes when you take a very long view, a multi-generational view. I would say when using a continuing trust, a trust protector is a must. So an inheritance protection trust is a continuing trust. A living trust that ends and everyone gets their check, that is not a continuing trust. A continuing trust is where money continues to be held in trust. And by the way, the individual beneficiary is oftentimes the initial trustee of the inheritance protection trust. And if they get into trouble, then they can stop being trustee. So we have a couple of questions here, and let me, before we get to IRAs and 401ks. Is a successor trustee also an executor, John? John asks. Yeah, so a successor trustee, again, this is a term of art, and I would say the closest analogy is if you're serving in the United States Army, you're a soldier. If you're serving in the United States Navy, you're a sailor. Same role in a sense, even like the same rank, like in an E1, but they're called different, so that when somebody says soldier, you know, oh, okay, they're part of the Army. Or if they say sailor, you're going to say they're part of the Navy. So those are terms of art, but oftentimes they're the same person, right? Different role, oftentimes the same person. Anonymous says, will the successor trustee be the trust protector after the parents pass? No, the trust protector, sometimes the trustee can be the trust protector. I would say in the vast majority of cases, I can think of one case where the trust protector is the trustee. And that's a trust that started in the 1930s and that had some iterations going through court on a particular matter. But I would say generally no, that the successor trustee is not the trust protector. Greg asks, may an inheritance protection trust be executed for the benefit of the children after one of two parents has passed away and or the surviving parent is experiencing cognitive issues. Yeah, Greg, I'm obviously, the parent is the one who signs it. That can be done, the parent individually. Sometimes it can be done through a durable power of attorney, if the trust and the durable power of attorney permit the estate plan to be amended in that manner. But I would say, probably, and that's something you could certainly reach out to us to talk about. Is a revocable living trust the inheritance protection trust after the parents pass? Yes. So what happens is these trusts are all sort of baked into the living trust. And so the living trust will say, while the parents are alive, the money's used for the parents' benefit. And then when the parents die, the trustee distributes the property equally to the kids in their own respective inheritance protection trust. And that's all contained inside of the living trust. But that's absolutely correct. So, so this is a big, I would say one of the biggest assumptions that are incorrect. I don't know if there's one word that that kind of conveys that meaning, but you need. I know I've been talking a lot about a lot of law, but on this one, you're going to kind of want to empty your mind a little bit. IRAs and 401ks and 403bs and annuities and insurance. Those are assets that when you die are distributed to a beneficiary. Okay. So what that means is they don't go through your living trust typically or necessarily. I mean, they can, but the reality is it doesn't matter what your trust says. It matters what the beneficiary designation says on file with the companies that are holding these assets. And whoever, and they have to be able to find that beneficiary designation, which sometimes they can't, right? Can you believe that? We've had instances where that's been the case. But whomever is named the beneficiary gets these assets. Now you can say, well, can't you name the trust the beneficiary? We'll talk about that in a little bit and why that's not a good idea for a lot of these. But the tax deferral concept, right? You put pre-tax money into a 401k while you're working, then you retire, you roll over your IRA, and then you start taking minimum distributions at age 72 now. IRAs have really become a big deal. They really weren't that big of a deal in the 80s, maybe even the 90s, but we have several clients, with IRAs well over 1 million, sometimes over 10 million. And, they become a big deal. And why? It's because if it's not a Roth, that's going to be subject to income tax. Your IRA, when you take that money out, of course, you have to pay tax on it, unless it's a Roth. And your kids or your loved ones, when they inherit these, are going to have to pay income tax on that money. And, the tax bracket arbitrage, this is, we have a graduated tax system. So the more you make, the larger the percentage of that next tier of income, the larger the percentage, the larger the piece of pie goes to the government. It's not just a flat tax system. And so what you want to do is you want to be mindful if you can take out more, right? You want to pay attention to what your tax bracket is, because if you waited to the following year, you're going to be paying less overall tax. So it's something you work on with your A team, as we call it, your CPA, your financial advisor, and your attorney. And these are very painful tax consequences. And again, we go into quite a lot of depth in the book on this, but bear in mind, each heir is on their own. So your trustee, if you say, look, I've named my 3 kids as beneficiaries of my IRA, each of those children is going to have to do something within a certain period of time. And sometimes people don't. Okay. So it's not that the trustee or the executor is the one handling this. It's going to be the individual people. Birthdays matter a lot. If you miss an RMD, a required minimum distribution after age 72, there's a 50% excise tax. So if you have to take out $10,000 in a year and you don't, and you miss that deadline, it's $5,000 tax, excise tax. Avoid the 5-year rule. So that's your RMD. Their RMD is the people you're leaving this IRA to. So we have a new set of rules, and actually the IRS released this week, I think it's 275 pages of regulations on the new IRA rules. Yeah, if you're having insomnia, just, open that up and start reading it. So the 10th year rule, what is that? When you die, your beneficiaries, in most cases, do not have to take any money out until the 10th year. If your beneficiaries the beneficiary is the person who inherits the IRA. If they don't do stuff that they need to do by September 30th of the year following your death, they're stuck with what is known as the 5-year rule, which is a penalty box, which means the money has to come out in substantially equal payments over a 5-year term. So it's very important to pay attention when someone dies, and let's say you leave the IRA to 3 people. Those 3 people have to do stuff on what may, if you pass away in December, September is not that long after December, especially when you lose a loved one. But we go in the book, we go over terrible outcomes, and we go over optimal outcomes. Roth conversion. A lot of our clients are doing Roth conversions. That may go away. What we do recommend, if clients have a larger IRA, we certainly recommend the Ira Legacy Trust that optimizes overall planning. The Ira Legacy Trust is not your living trust. The Ira Legacy Trust is a totally separate plan specifically for your IRAs. And, this is where reasonable minds can differ. I talk to a lot of attorneys. They say, Jim, you're full of it. You can certainly write all these provisions into your living trust. I agree with that. The problem is if I write these complex provisions in a client's trust, and then the client amends their revocable trust, which they can amend, that amendment can totally unravel all the planning and cause all the money to come out in the year of your death. Okay, so that would be all income that would be realized in the year of your death. That would be the worst outcome. And that's real because people will amend their trust inadvertently. Okay, they might do something in an amendment to cause the plan to be unraveled. The Ira Legacy Trust is a separate standalone solution to this problem of, hey, if my heir inherits $1 million IRA, 10 years from now, it's going to be worth $2 million. When that money comes out, that's $2 million in income, right? You're going to have to add that to your income in the year that comes out. Now, that's a designated beneficiary. By the way, designated beneficiary is a human being with a heartbeat. So it's a human, not a charity, and you have to be alive. Your heart has to be beating. So eligible designated beneficiary is a special type of beneficiary, and you get the old lifetime stretch. And that's if it's a minor child, someone who is disabled, or someone who's chronically ill. And those chronic illness is basically an inability to work, but not necessarily disabled. And that's defined in the Internal Revenue Code. You do get a lifetime stretch on that. So this is where, if you have a loved one with special needs, maybe you've got 3 kids and one child has special needs, you might want to think about leaving more of the IRA to the child with special needs because you do get this lifetime stretch. So I know it's, again, a little in the weeds. A spouse can certainly roll it over, but if your spouse is younger, if you're under 59 and a half, you may not want to roll over all the IRA if you need to live on that money because you have a 10% extra tax if you make a pre-age 59 and a half withdrawal from an IRA. So I know I'm just throwing a lot at you, but no, this is a very esoteric subject. I find that very few estate planning lawyers are sufficiently educated in this area. Also, look at jurisdictions. Many times we'll use Nevada as a jurisdiction for a trust because you have a 360-year RAP is rule against perpetuities, meaning these trusts can last up to 360 years. And again, leaving your IRA to a living trust, bad idea. And the other issue is, hey, for a lot of people, their IRA is their single biggest asset in their estate. And if you just name individuals, there is no creditor protection. Think about that. What if your kid inherits your IRA? Let's say your kid inherits $1 million IRA. The kid gets divorced. How does that even get split up? A judge could certainly order the child to fork over half of that $1 million IRA. Well, that means 500,000 is coming out. That's going to go on someone's income tax return. Who pays the tax on that? It's an open question. We don't know. So relying on your living trust as a tax plan. Everyone hates a death tax. I mean, pretty much everyone. Right now, you can leave 24 million tax-free if you're married, or 12 million if you're single. So, some people have more than that, but 99.7% of the population does not. So it affects a very small number of people. Something to understand is states have their own death taxes too. Countries have their own death taxes. If you're going to leave Property to a German relative, they have their own inheritance tax structure that starts at, I believe, 20,000 euros. So it's a very low threshold. AB trusts are largely obsolete. We do cover that in the book. What is an AB trust? That's a split. So a living trust that says when one spouse dies, the property is split into two buckets, typically an A trust, which is for the alive spouse or the above ground spouse. And the B trust is for the below ground spouse or the buried spouse. That's that B trust spouse is where, so if you're the deceased spouse, your half of the property goes into the B trust because you're buried or you're below ground. And that's how lawyers remember the difference between A and B. And those are largely obsolete. They were created, it was a solution to a problem, and that problem went away in 2011. So a lot of people have these legacy trusts. The problem with the B trust is assets. If you fund a B trust with $1 million and the assets go up to $2 million and your kids inherit that or your loved ones inherit that B trust, they're going to have a capital gains tax issue, right? Because the basis stays at $1 million on that $2 million asset. And that's one of the large issues in these AB trusts. Real estate, something to understand, real estate is taxed differently than intangible property. What am I talking about? If you own that rental property in Oregon and you're a California resident, Oregon has a 16% death tax over $1 million in assets. That real property, if it's in your estate when you die, is subject to Oregon death tax. If it's in an LLC, it is not. Now you cannot, let me say this again, if you take that rental and you put it into an LLC, it is not subject to death taxes because you now own these LLC interests, which are considered an intangible, right? I mean, it is a piece of paper, but it's a property right. It's intangible. So you can't do that with your vacation home though. And Oregon, that's the one jurisdiction I know enough about to, they really don't let you skate by with a personal use asset. It has to be a business asset, like a rental property. Charitable trusts, we've got a lot of content on charitable trusts. Those are a way to either help charity a lot. They're a way to bypass capital gains tax or defer it. And it's also a way to defer a tax deferral strategy as well. So fundamentally a tax deferral strategy, not so much tax avoidance strategy. Gift annuities, that's where you give, if you're 92, you give 100,000 to American Red Cross and you get 8.6% a year for the rest of your life. If you're 72, you get 3.2%. So the older you are, the bigger the return, because what a gift annuity is half the money goes to charity, half comes back to you in income over your lifetime. And the older you are, the shorter your life expectancy. And that's why those numbers are different. GRATs is, we have a lot of content on GRATs and IDGITs. Those are advanced tax planning strategies, grantor retained annuity trust, and intentionally defective grantor trust. Now, we got a couple of questions. I'll answer these questions and then we will finish up with our last three. How is a continuing trust different from the inheritance protection trust? A continuing trust is, an inheritance protection trust is a form of a continuing trust. Continuing trust also includes a special needs trust and the dole it out trust. So it's the general descriptor. When the person is the beneficiary for IRA's life insurance, will the benefits be subject to divorce and creditors? Yeah, so that's a problem. Now, here's what I tell clients is, lawyers can't say absolutes. So I'm saying this not in an absolute sense, but I want it to be clear. If the property is community property, it's not going to become separate property. All right. It just doesn't happen. You have to go to a lawyer. You have to do a post-nuptial agreement. You got to jump through a lot of hoops to transmute community property to separate property. It's like a ball does not roll uphill, right? If you take separate property, that can very easily become community property, very easily. It's like a ball rolling down a hill. What do I mean by that? Well, let's say, imagine there's a divorce proceeding going on and the divorcing spouse who wants that separate property treated as community property, the divorcing spouse says, well, my spouse told me that it was community property and this is the really important part, and used that separate property to make community property, to pay community property obligations, rent on a house, payment on a car, or whatever it is. That's where it can be a a judge is free to say, yeah, well, that's a transmutation to community property, and it's going to be subject to a 50-50 split. Dana asks, what about naming a trust as backup beneficiary if your child's a minor? You know, Dana, potentially, if you have a minor child and an IRA of any substantial size, I would recommend you consider the Ira Legacy Trust. It's what we call it. It's also called the Standalone Retirement Trust, which I'm not a fan of that title because I don't think it is clear enough. Why is leaving IRAs in a trust a bad idea? Anita, great question. It's because to be a designated beneficiary, to get the 10-year delay on the money coming out of the IRA, you have to be a human being with a heartbeat. A living trust is not a human being with a heartbeat. The Ira Legacy Trust has what has certain provisions where the IRS disregards the trust, right? And looks through to see who the beneficiary is, who the person is who's receiving the assets in the Ira Legacy Trust. A living trust has a lot more stuff in it that causes that to be a real problem. A living trust has a lot more terms in it that are inconsistent with the IRS treating that trust as qualifying as a designated or an eligible designated beneficiary. Ira Legacy Trust protects from divorce creditors, but a revocable living trust as beneficiary doesn't protect. Well, it depends on how the trusts are written. If they're written as continuing trusts in these inheritance protection trusts, then they would be designed in a way to protect those assets from creditors and divorce. So, assuming your trustees will know what to do, you know, these trusts don't resolve themselves. It's a document. People have to do it. So trustees, executors, and beneficiaries all have to do stuff, right? They all have to take action. Everyone has a part to play. The beneficiaries have to comply with, you know, here's my address, here's my banking information, right? If you're going to do a wire transfer on the inheritance, there's stuff that people have to do. Certainly with IRAs and life insurance, the beneficiary may be making a claim for part of that. And so what does a trustee do? Well, a trustee has three functions after somebody passes away. One is to inventory the assets. What do you have? Take control of it. The trustee's name goes on the bank accounts, right? Trustee of the trust. Trustee goes on title to real property. Then pay debts and taxes. You got to pay debts, right? This is kind of like a bankruptcy in a sense. You got to pay debts and the taxes. And then what's left over, you distribute as the trust directs. Now, that sounds simple. It sounds pretty straightforward. It sounds like you can do it on your own. Don't. It's a bad idea. Meet with a qualified lawyer, you know, whether it's our firm or someone else's firm. Meet with a lawyer. If you're named as trustee, you absolutely have to meet with a lawyer first. I would say in most instances, we end up, the trustee needs help. In some instances, the trustee does not need help, but in that initial meeting, and you should be, by the way, you should be expecting to pay for that initial meeting because a lot of value is given on that first hour or hour and a half. And any attorneys who know what they're doing will not do that on a freebie basis. But it's important to meet with a lawyer to know. Remember, I said in the beginning, it takes an expert to know what's missing. There's a lot of stuff that's missing from a trust that's just not in there. It's called, you know, California law, California case law. In this particular type of situation, what are the rules? And they're different based on the situation. So very important to meet with a qualified lawyer. Digital assets and crypto. That's a whole, we did a webinar on crypto. That is a developing area. I will tell you, the law absolutely is not caught up with crypto. I think if you only have your pass key and it's physical or it's some type of password, if you pass away, what we see in the news, in the legal specific news, a lot of that is just lost. So, and there are a lot of ways you can hold digital assets and hold crypto, but I think that needs some special attention. Credit cards are an interesting one. Credit cards, we typically, as a law firm, we send a letter saying the person's passed away. If the trustee does it, guess who's going to keep calling you? The credit card company. You want the lawyer to communicate with the credit card company, even on a very small estate, because those people just it's like a dog with a bone. They just won't let go. And then funeral expenses, stale trust. So a stale trust is an out-of-date trust that hasn't gotten enough attention. Sometimes it's worse to have a stale trust than nothing at all. Guns, I know this is can be a political topic, but firearms are regulated not only federally, but also by individual states. It is a federal crime to go from one state to another to deliver a firearm, even if the person is named to receive it. That is a federal crime. So we always recommend that our clients go through the federal firearms licensee, which is an FFL, which is like a gun dealer, and they can make sure that the transition is proper. There are family exemptions, but again, the California has 3 pages of descriptions. It's a list of what constitutes a prohibited person. That is a person who cannot possess a firearm. That means it can't be in their hand, so it can't be in the house. Right. So there's a long list of people. And so you don't want to commit an inadvertent felony on that one. Choosing a trustee. I think, this comes up a lot. Should you do 1 or 2? I think 3 is too many. If people get along, 2 is okay. But, you have to look at, do they know how to do this? Are they white of heart, but empty of brain, meaning they're a good person, but they're, they don't have the mental horsepower to administer a trust or the training. Temperament is important. I think you need someone who's going to be conciliatory and rather than someone who's overly aggressive. Trust company versus trust bank. A trust bank is going to be like your Wells Fargo. It's going to be a U.S. Trust. Those are the big boys. And then there's the trust company, which are typically in Nevada, Tennessee, South Dakota, and Alaska in the zero tax jurisdictions. Trust companies charge less, big banks charge more. A big bank's going to typically liquidate your stock portfolio and invest in their own mutual funds or proprietary stuff many times. But it's something you should investigate both if you're thinking about a trust company. Who's looking after the trustee? There's no court supervision. That's the one downside of a living trust. And trustees have 100% personal liability for all their actions that they take and the ones that they don't but should have. So that's another thing to consider before you're named, before you become trustee. Forgetting to keep up with changes and not staying in touch. Okay, if there's a birth, death, divorce, or a marriage, that's something that's a triggering event. You need to look at your estate plan. If any of these people named in your estate, if any of those events happen, you need to take a look at your estate plan. People turning 18, and you can see the ages here. People who are 55, you're planning for retirement. And 60, you're starting to think, maybe I'm retiring. Should I do a Roth conversion? 65, you get Medicare, you're looking at Social Security. And then your RMDs start in your 70s. And then I would say when you hit 80, and I know these are sweeping generalizations, really think about getting other people involved because, the reality is that most people do have some type of cognitive decline. The world gets more complex, and many times people just need help from somebody else. So don't be afraid to ask. Avoid a failed estate plan. And you do this by checking in with your A team. And we've mentioned this in the past. The A team is typically your attorney, your CPA, your financial advisor. And I would say, look at it annually, meaning every year, look at your estate plan. And then every 3 years with a lawyer, or when there's this sort of birth, death, divorce, or marriage. The number one mistake people make is procrastination. You have stopped procrastinating because you're watching this, right? For those of you who stuck it through all the way to the end, remember, inaction is a form of action, right? And have you done your job in getting your estate affairs in order and keeping them in order? And how do you get started? Well, you can certainly reach out to us at Cunningham Legal. You can click request an appointment. You can give us a call. And we are happy to talk. There's even a chat feature there. We don't make it hard to reach out to us. And go ahead and subscribe to this if you're watching this on YouTube, and share it if you think this is of value. Also, review us on Google. You can go to our and go into Google and we pop up if you Google Cunningham Legal, and you can give us a review. So we have a few questions here. I'd like to get through these questions and then we'll wrap it up. Is the successor trustee also okay? Catherine says, I'm in my early 40s, good health with young children, so my cash needs may change in the future. Should I set up a revocable trust now for the benefit of my children in case I need the cash later, or is there a better solution, or should I hold off until I'm older? Well, Catherine, I would say that you should have an estate plan. Whether you do a will-based estate plan or a living trust, I think you need to speak with an expert lawyer. We'd be happy to talk to you about that. Most of our clients end up doing a living trust, but I would say, kind of the tipping point on that is if you're a homeowner, you probably should be looking at a living trust in California. Colleen asks, what should we budget for estate planning to set up a living trust? We have our highest viewed YouTube video, I think it's almost at 30,000 views, is how much should a living trust cost? A living trust typically costs the cost of a living trust. What we see most attorneys, and this is California, you're going to see most foundational plans, probably 3,000 to 7,000, maybe 8,000. What do I mean by a foundational plan? That means your living trust, and it's more if you have an IRA trust, but that's what I'm seeing with other firms. Those are firms that charge on a flat fee basis. So in that sort of 3 to 7 is a range, maybe 3 to 8. If you get below 3, I think the people who are doing that, I'm not sure that's enough. I'm not sure that's enough money to pay all the people that need to be paid to get the job done. So it's kind of like buying a new car for $5,000. You're like, wait a minute, it's kind of weird. Is an Ira Legacy Trust irrevocable? Yes, but you can change the beneficiary. So it is irrevocable, but it's not funded until you die. So you have the ability to change the beneficiary to a new irrevocable trust. When you say trustee, is it the successor trustee? Yes, it's the successor trustee. That's correct. Anonymous asked, is the beneficiary to be person for Roth IRA and IRA? If the RLT is beneficiary IRA and Roth IRA, is all the amount in the IRA to be taken out the first year, and the 10-year rule can't be used? So stated another way, if you leave your IRA to a living trust, are you going to get that 10-year stretch? I would say probably not. And I know this because I've picked up where other attorneys have kind of not done such a good job. And I've gone toe to toe with the IRS, smartest attorneys I've ever spoken to in Washington, D.C. And I asked them straight up, look, if this was an Ira Legacy Trust, would we even be having this conversation? They said no. The problem is it's a living trust. So I think the attorneys who are telling people, leave it to your living trust, I think they're not well informed. It's the bottom line. If the children inherit an IRA without an IRA Legacy Trust, do they have to have another trust to protect the benefit from divorce? Yeah, you have to set this up. There's nothing they can do once you pass away and they inherit that IRA. That is, you can't put that into a trust. They can't. It's too late. Okay, so you have to set that up while you're alive. Josie asks, I'm a real estate agent. I'm learning from your Zoom meeting a lot. Thank you so much. Well, thank you, Josie. How much is an IRA Legacy? Anonymous asks, how much is an IRA Legacy, an irrevocable life insurance trust cost? I think it depends on, it's case specific, but I think you're probably going to be in that range that I was talking about, sort of that 3 to 7 range, maybe 4 to 7. Also depends if it's an individual trustee of the life insurance trust or an institution. It's typically more if it's an individual to set up, because that individual has to be trained. Michael says, is an online living trust legal? Does it need to be notarized in California? Yeah, Michael, I would say an online living trust is typically done. If what you mean by an online living trust is some type of software or something or some paralegal, I think estate planning is one of those things that should be done by a qualified lawyer. It's just too important, and you won't know the outcome until you're gone. And the disasters can really be big. I think it makes sense to at least consult with the lawyer. Whether you continue to do the online solution, that's up to you. Why is ILIT so important? So life insurance, something to understand is life insurance is included in your estate when you pass away. The death benefit on the life insurance is included in your estate. And the life insurance trust makes it so that it's not included in your estate, but you have to go through a lot of hoops. And that's a lifelong commitment on your part if you choose to do that. So let's see. What about using Legal Shield that's offered by our work? Colleen, the Legal Shield, the reimbursement is so low for the lawyers. Most lawyers who know what they're doing don't participate in that. That's what I see. Do we amend an existing trust? Yeah, Carol, sure. So what we typically do, if you have a living trust and you want to make some changes, we typically do what's called a restatement, which is technically an amendment, but it amends all the provisions. Colleen says, how far out are you already booked for appointments and how long does it take to put a living trust together? Colleen, our service cycle is about 5 weeks. I know we have availability. If you called now, it probably would not be with me. It would be with another attorney, but I know we have availability. And the reason I say that our service cycle is 5 weeks. So we do drafts and give those to you, and then we give you a couple of weeks to live with them, right? So part of that is just living with it, looking at it. You know, it's there on the kitchen table, and it arrived last week, and I'm still nervous about looking at it. So it mentally takes a little bit of time for some people to look at this. So another great presentation. Well, thank you, Richard. And can a revocable living trust be a beneficiary for life insurance? Anonymous, yes. Here's the caveat. I'm a pilot. I never had my life insurance left to my living trust, because if I have a bad day, which is a euphemism for dying while you're flying, if I have a bad day, that life insurance is in my trust, which means it's available to pay my creditors. If I leave it to my wife, it's harder, right? So I would say it's case specific. Generally, it does go to living trust, but it's case specific. Is an ILET needed when the estate is more than the limit? Is it needed? It's a good idea. But a life insurance trust typically is only for permanent insurance. If the insurance is term, and you know it's term because it will say 10-year term or 20-year term, at the end of that 20 years, you're not going to want that policy anymore because the premiums will be too high. We typically do that for permanent insurance. And you can go to CunninghamLegal.com, estate planning book, for ordering information on the second edition of Savvy Estate Planning. And with that, it has been a pleasure to spend some time with you, and we look forward to seeing you in the future.